It is 9 o'clock. Welcome to the Finance Committee meeting today. Today we are deliberating on the legal opinions provided from the Western Cape Provincial Parliament's legal advisor and the Department of the Premier State Law Advisor in respect of a matter arising from deliberations on the submissions received on the Western Cape 19th Gambling and Racing Amendment Bill, B1-2020. My name is Deirdre Bartman. I just want to quickly check with the procedural officer and our IT advisor whether the meeting is being recorded and whether we are online yet.
Good morning, Chair. The meeting is being recorded.
Thank you. And are we online on YouTube?
We are live.
Perfect. Thank you so much. Colleagues, I'm going to quickly just run through our rules of engagement. And then after that, I will ask that the members introduce themselves. And then I'll ask that the respective officials just introduce themselves. And then if there are anyone else also in our meeting as an observer or from the public, that they also just introduce themselves, please. So just a reminder that all mics need to please switched off. And this is just to prevent background noises. And if your video is on, we ask that you only keep your video on for when you are on the floor. And if you would like to raise a point of order, you're welcome to use the raise your hand function, as well as put your points of orders in the chat function in the MS Team box. We also ask that if you're sharing a presentation, that you share your presentation yourself and unshare once it is completed. And then again, as normal meetings, all normal rules of committee meetings apply, subject to the online amendments that were made by the speakers. Further, I have an apology that I just need to table before I ask everyone to introduce themselves. I received an apology from Mr. David Savage, the head of the Provincial Treasury. Okay, members, I'm going to now ask that you just introduce yourselves.
Dankie, Voorsitter. Good morning, everyone. Dylan Mitchell.
Thank you, Member Mitchell.
Good morning, Chair. Andrikus van der Westhuizen.
Morning, Member van der Westhuizen. Member Nkondlo, are you there? I see your picture, but I think maybe you're struggling to unmute.
Good morning, I'm Member Nkondlo, member of the committee. Thank you.
Thank you, Member Nkondlo. I don't see any other members on the participants list here. If the officials could just introduce themselves, please. I'll start with Provincial Treasury.
Good morning, members. Chairperson Anthony Phillips, Provincial Treasury.
Thank you, Mr. Phillips.
Good morning, members. Dr. Danlea, Provincial Treasury.
Thank you, Doctor.
Good morning, Claire Horton, Provincial Treasury.
Thank you, Ms. Horton. If there are no others from Provincial Treasury, if we could have the officials from the Department of the Premier just introduce themselves.
Good morning, Chair. It's Astrid Miller, State Law Advisor at the Department of the Premier, Legal Services.
Thank you, Ms. Miller. Is it Ms. Miller or Advocate Miller? Because on my documentation it says Ms.
Ms. Miller.
Okay, thank you. Anyone else?
Good morning, Chair. It's Anita Vosloo, Legal Services Department of the Premier.
Thank you, Ms. Vosloo. Are there anyone else from the Premier's office? If not, if the officials from the Western Cape Provincial Parliament could just introduce themselves.
Good morning, Chair. Romeo Marsop, Legal Advisor for Provincial Parliament.
Thank you so much, Mr. Marsdorp. And from our procedural side, we have Ms. Kluter and Ms. Adams and Mr. Hassam that are with us today to assist us with procedure and with IT from the committee side. I'm going to now just ask, I see a few names that are not officials or members. If the persons from the public or stakeholders could just introduce themselves, please.
Good morning, Chairperson. Esty Brown from Edward Nathan Sonnenbergs, representing Tofasan and Bukani Gaming, just observing the proceedings today. Thank you.
No problem. Thank you so much. And I think I just missed Ms. Morris that are also joining us from Western Cape Provincial Parliament today. Thank you so much for being with us and assisting us with technical details. Members, so the context for today's meeting is that previously, out of deliberations on the Western Cape 19th Gambling Amendment Bill, there were some concerns from stakeholders regarding the constitutionality of the objective of the bill, which relates to the industry paying for itself, and whether some stakeholders, such as casinos and LPM operators, should be bearing the bulk, and whether others should not be or should be in the bill and also be paying operator fees. We then requested legal opinion. We requested legal opinion from the Western Cape Provincial Parliament through Advocate Romeo Maasdorp. We also requested legal opinion from the Department of the Premier via Ms. Miller. Okay. We then received the legal opinions. I must apologize, the legal opinions were sent 1 day late. But the reason they were sent 1 day late is because everyone at the Western Cape Provincial Parliament were having computer problems. We were receiving boxes of security certificates and software that needed to be updated in that particular week. So apologies due to those technical difficulties in IT. We did send it 1 day late to everyone. Colleagues, so you would have received the 2 legal opinions, and we would just deliberate on those particular opinions today. The one opinion from Advocate Maasdorp did not have a confidentiality disclaimer on it. The second one from the Department of the Premier had a confidentiality disclaimer on it. And I would like members to first discuss the topic of confidentiality before we move forward in deliberating the content of the legal opinions. If there's members who would like to speak on this. Going once. Honourable van der Westhuizen, I see your hand.
Good morning, Chair, and good morning, honourable members. Honourable Chair, I see that the one legal opinion is marked confidential. Now, as a default, we as a committee ensure that all our documents, etc., are public. And I would like to ask from those that drafted the legal opinion, who is taking the ownership for this opinion, whether they would have any concerns if we declassify this document and transfer it into an open domain, and therefore use this as a document of public record.
And you're just freezing a little bit.
Sorry, I've now switched off my video and I trust that it will improve the sound. My question is whether the owners of this document would have any qualms or problems if we as a committee declassify this document and therefore treat it as a document of public record, and therefore ensure that it can also be taken up into the public records and the documents supporting this committee's deliberations. Thank you. Could you hear me, Chair?
Apologies for that. I was just moving closer to my connection because it seemed that my computer is saying that I needed to do that. But from yourself, I heard that you would like us to consider opening it up unless the respective person who wrote the opinion has an objection for confidentiality reasons. Am I correct?
Correct. Thank you, Chair.
Okay, I'm going to see Honourable Nkondlo's hand first before I go to Ms. Miller.
Thank you, Chairperson. I would like to support what Member van der Westhuizen has said, and I think in considering that request, I think it should be noted that we are a committee of parliament, and the matter arose out of a debate on a particular piece of legislation that requires, an open and transparent process. And given the nature of our work in this regard, I think that indeed that request should be considered in that light, unless indeed such could be clarified where could be, the challenges of placing this matter, which already now, given the participants in this session, that we do have in the presence of the committee members of the public. So I think that should be considered in the request which is placed by Member van der Westhuizen, which I fully support to declassify the information for the purpose of concluding our work as a committee. Thanks.
Thank you so much. Ms. Miller, I did see your hand, but I'm going to quickly take Member Mitchell's hand so that I can exhaust all of the members first.
Thank you, Chair. No, I wanted to support Honourable van der Westhuizen and Honourable Nkondlo's suggestion.
Thank you so much. Ms. Miller, do you have any objections?
Chair, with regards to the protocol for obtaining legal opinions, normally what occurs is that a standing committee would ask its legal advisor to provide a legal opinion, and then that legal opinion is provided to the Department of the Premier Legal Services to comment on. But because the committee requested me directly to prepare the legal opinion, the opinion was prepared for the committee, and it's legal advice, and hence it is normally legally privileged and confidential. And given that the opinion was prepared for the committee has the choice whether or not to waive that privilege. So it's the committee's prerogative.
Thank you, Ms. Miller. Members, any view on that? I see Honourable Mitchell's hand. Member Mitchell, is your hand taken down from previously?
Yeah.
Okay, then what I'll do is I'll quickly, no problem. Then I'll quickly just take Ms. Vosloo's hand so that we can exhaust then the hands from the department. Ms. Vosloo.
Thank you, Chair. Just to add to what Ms. Muller said, the insertion of the privilege and confidential on the front page of the legal opinion, those are standard. We do that on all legal opinions. So it's not that this opinion was, being dealt with differently. And also just to support what Astrid said, we were placed in a little bit of a different position in that ordinarily, because we are the executive's legal services, we would provide a legal opinion to the client department, which would be Provincial Treasury. So that complicated things a little bit. So because we were instructed by the committee to prepare the opinion, we then had to do so. But ordinarily, the advice to the committee would come from legal advisors at Parliament, with the departmental legal advisors to respond to whatever view the legal advisors at Parliament held. So this was why it was a little bit different. Thank you.
No problem. Thank you so much for the clarification. Honourable van der Westhuizen.
Thank you, Chair. Taking into account what has just been said, I would like to formally submit the motion that this legal opinion be declassified and be made a public document by the committee. Thank you.
Thank you. Members, are you in support? Honourable Mitchell.
Supported.
Support, Chair.
Thank you, Honourable Nkondlo. Thank you, Honourable Mitchell. We are thus unanimous that the document will become a public document, and we will be thus considering it in an open platform today. With that, I will then ask Advocate Marstorp, would it be possible for you to speak us through your particular legal opinion? And then if I could then ask Ms. Miller if she could speak through their legal opinion as well for the members, just to understand, because not all of us necessarily have legal background, and just so that we can understand what is being argued specifically. And if there are any differences between the legal opinions, if you could just highlight what you differ with the respective, with either the Provincial Parliament or with the Department of the Premier, if possible, please.
Thank you, Chair.
I'm just going to put my video off because I don't want to lose you all. I already had some connectivity problems now, so I'm just going to put my video off in the meantime, but I am here.
Thank you, Chair. Can you hear me now?
I can hear you, yes.
Chair, I would not want to purport to summarize my opinion, but with a brief input, and in the process either undermine the opinion in its written form or just lose salient points which may be crucial in the deliberation exercise. Safe to say at this stage, and since the opinion is a public document, like I said, I would not want to undermine the opinion in its written form. Safe to say at this stage that it boils down really to two things. One is the test for rationality, and the other is that everyone is entitled to be treated equally before the law. Those are the two primary considerations when one looks at what this bill seeks to do and what it actually does. Now, in the opinion, I've made reference to various cases where these principles, but namely rationality test and equality before the law, have been, I want to say exhausted, but I'll rather say has been relatively sufficiently dealt with. And as I said, in the opinion, I make reference to those cases as well, and some of those cases have been referred to by my colleague, Ms. Muller, as well. But let me summarize it in the following way, and I'm just trying to scroll to my opinion so that I can at least read for the record what I think should be the primary considerations. The first thing, and I'm paraphrasing now, the first thing, Chair, is that it is the stated purpose of this bill to provide for the board's eventual self-sufficiency. And I'm still paraphrasing. And as a means to do that, the bill seeks to provide for the increase or the introduction of certain fees. Because the board, so the bill provides, by introducing or raising certain fees, will then become self-sufficient, and the sponsors of the bill also adopted the principle that the industry should pay for itself. So the bill now seeks to provide that those players, in inverted commas, in the industry should in fact pay for their regulation and their maintenance. The means used as provided for in the bill is for the, like I said, the raising and introduction of those fees, to the exclusion of certain other players. However small, however many they may be, it is to the actual exclusion of those other industry members, participants, or players. What now happens is that the bill, in its attempt to lead to self-regulation, differentiates between certain players without, and this is my contention, there being a rational basis for that differentiation. My colleague, in her opinion, argues that, and my colleague, in her opinion, refers with approval from her to certain case law where it is said that no matter the means used to obtain a particular purpose, no matter how unreasonable that means may be to obtain a particular legitimate governmental purpose, or no matter how appropriate that means used may be to obtain a particular governmental purpose. And my colleague argues that the means used, that is, the raising of fees, the introduction of certain fees, that means is a reasonable / fair or an appropriate way to achieve its end. In other words, the raising of fees is a fair and appropriate and reasonable measure to obtain their purpose. I am arguing that that may even miss the point, because if those means are fair and reasonable and appropriate, it only seems to be applicable and it only seems to pertain to some in the industry. So the means, as this is my contention, is not even the consideration here. I may even want to concede that the means is reasonable. But I am saying that the reason for excluding others is irrational. So not so much the means that is under fire or under attack in my contention, and I've written to this effect in my opinion. I am arguing that there's a disconnect, there's an incongruence in the application of that means. And I'm arguing that that is an irrational differentiation. If it was that the bill was to provide for a means, or let me use another example. If it is that the bill provides for a particular means which objectively would be irrational, objectively would be inappropriate, then that means that measure would have been applicable to all in the industry. But like I said, I am arguing that I am willing to concede that the means may be appropriate, but that very appropriate means has a irrational differentiation between those players actually impacted on and those excluded. I have also noticed that my colleague argues that this is, as a matter of, this is a policy decision, in other words, the exclusion from the provisions of the bill of certain players. It is a policy decision, and I'm arguing that it is therefore not a principled or a fundamental decision. Again, it confirms my point that if it's not principled or fundamental and it's mere one of expediency, then it even more underscores my observation and my contention that the differentiation by excluding others. Take note, I'm not even talking about the means used. I'm saying the very means unduly, unfairly, and unreasonably differentiates between those who form the industry. And if government's purpose is to get industry to regulate itself, or rather pay for its own regulation, then how is it arguable, persuasively arguable, that some in the sector should pay for the rest? I do not want to say much about my colleague's contention that it is a policy decision that's been made some time ago, and then this bill flows from that policy decision. I would not want to say much. In fact, I shuddered when I read that, because not too many decades ago, there was a policy decision made in this country which caused the birth of umpteen of legislation that ravaged this country. So a policy decision that informs law, I shudder when that policy decision in and of itself is questionable. The exclusion of certain players at this stage, as was said, the exclusion of players to be considered at a later stage seems to be the predication for the birth of this bill. I'm arguing maybe that policy should be reviewed because it may just give birth to bad law. This bill must stand on its own feet. As it stands now, it differentiates between players. The differentiation is unreasonable, it is irrational, and in fact undermines the very purpose which government says it has as a legitimate purpose, which is to maximize its revenue streams. By only introducing fees in respect of some, that very purpose is undermined because it does not and will not effectively maximize the revenue yield that they purport to obtain. Chair, I'm not sure if I did justice to the written form, but for the record, I just want to read for the record the following. I'm saying, and this is where I'm reading now from my conclusion, I submit that the bill, by seeking to impose certain fees on only some in the gaming fraternity, to the exclusion of the majority, undermines and negates its own stated purpose of eventual self-sufficiency. It is further submitted that this exclusion of others from the reach of the bill is not rationally linked to its stated purpose and undermines the objective of the industry must pay for its own regulation. I lastly submit, Chair, that this deliberate exclusion is without basis, is arbitrary, is without legal rationale, and will, I am confident, full of the principle of legality. That very briefly, Chair, unless there's questions to me.
Thank you, Advocate Master. Before I accept questions to yourself, I'm going to first allow Ms. Miller from the Premier's office to just speak us through her document. And because the two documents are quite long in terms of the respective legal opinions, instead of flighting them, I'm going to just ask that the procedural officer just uploads the documents similar to all of our other documents that we always upload for committee meetings in order for it to be made public in the general manner. But Ms. Miller, if you could just talk us through yours, The members did obviously get all of the documentation as well, and it will be made available online as well publicly.
Thank you, Chair. I appreciate the opportunity to address the committee regarding my opinion and a bit of the thinking that's included therein. As Advocate Marsdorp indicated, I would also prefer not to have any of the arguments therein. Essentially, I wouldn't want to undermine the arguments that are contained in the written opinion, and I would prefer that the committee have regard to that. But I do think it is necessary to go through a bit of my thinking. But before I do that, I just wanted to explain for the committee's benefit some of the terminology that I use in the opinion. When I talk about differentiation, what I actually mean there is that parties are being treated differently, but in a way that does not amount to discrimination. So, for example, distinguishing between different types of prisoners, doctors or lawyers, or even different classes of taxpayers. Those are all examples of differentiation or mere differentiation. So it has nothing to do with matters such as race, gender, etc., that are mentioned in Section 9(3) of the Constitution. And it has also nothing to do with similar matters, for example, HIV status or citizenship. So in this case, we are actually dealing with mere differentiation. And mere differentiation will be constitutionally permissible if there's a rational basis for it. So that takes one to the meaning of rationality. What does this entail? Essentially, it's an evaluation of the relationship between means and ends. One looks at what is the government trying to achieve? So that's the legitimate government purpose. And what means or method did government choose to achieve that objective? So then one looks at, is the selected means actually capable of achieving government's objective? It's an objective inquiry. And importantly, this is what I wanted to point out, it's not aimed at testing whether the legislation is fair, reasonable, or appropriate. I have actually not made that submission in my opinion, because that is not the test for rationality. So even if objectors are of the view that the legislation is unfair or unreasonable or inappropriate, that is not the test that we have to look at today. So it's aimed at looking at whether there are, it's not aimed at looking at whether there are other means or even better means that could achieve the objective. We are merely looking at, is there a link between what government wants to achieve and the actual means they have selected? And in this case, we are dealing with differentiation. So what we look at is this differentiation actually objectively capable of achieving the financial self-sufficiency of the board? And so now with regards to Advocate Marsdorp's opinion, the opinion proceeds from the basis that the exclusion of certain industry players is not for fundamental reasons or in any way based on principle. Essentially, it's based on timing and short-term expediency. This is, you'll find that argument on pages 13 and 14 of Advocate Marsdorp's opinion. But with all due respect to my learned colleague, the opinion actually proceeds from a flawed premise. It misunderstands the reasons for the exclusion of the totalizator and bookmaker industries from the bill. It is not simply an issue of timing and short-term expediency, and the reasons for excluding totalizators and bookmakers are set out quite fully, in my opinion, at pages 7 to 9. And also the department has attempted to answer this question in the matrix of comments. You can refer to pages 15 and 27 in this regard. So the real reasons for the exclusion of the totalizator and the bookmakers from the bill, it relates to certain challenges that are applicable to these industries. And given these challenges, the department has decided not to charge them operator fees at this stage. And Advocate Marsdorp has also argued that the financial net must be cast as wide as possible in order to achieve maximum financial yield. You can refer to pages 10, 11, and 14 of his opinion in this regard. But with all due respect to my colleague again, this argument does not take into account the nature of the gambling industry, the fact that there are challenges with the totalizators and bookmakers, and the fact that logically, there are only two operators who can sensibly be charged these fees, namely the casinos and the LPM operators. This argument, in my opinion, is dealt with in or from pages 7 to 12. And it's also noted that Advocate Marsdorp's opinion takes issue with the comments in the matrix that relate to rationality, as they do not specifically address the differentiation aspect. But the comments, it should be noted that they were actually of a general nature, and they should be understood within the context of the explanation provided by Treasury in the matrix regarding why it has taken the position not to charge totalizators and bookmakers. And it actually, it's too simple to argue, it's an oversimplification to argue that it relates specifically to timing. It actually has to do with challenges with the industries, with the totalizators and the bookmakers. So just to take you through those challenges, this will be canvassed, it's canvassed on page 7 to 9 of my opinion. So with regards to totalizators, in summary, the department has explained the following with regards to the totalizator industry. Essentially, they have been in steady decline for a number of years. And this is because players are moving over to other forms of gambling, which are instantly gratifying. And this shows that they are a sunset industry, meaning that they actually may not be sustainable in the future. Kenilworth Racing, which is managed by the totalizator, does not have sufficient funds to cover the costs of hosting horse racing events. And thus the government has provided funding to them from the taxes received from bookmakers. And the department has also indicated that charging the fees could actually contribute to the closure of the totalizator industry. And if the industry folds, then this would mean that the board will be without the fees that they currently receive, as well as any new potential fees like operator fees. So, and also importantly, that province will also be without the existing tax revenue. We must bear in mind that the objective of the bill is to ensure that the board is financially self-sufficient and that its costs are defrayed. It would not be sensible to link the sustainability and the costs of the board to an industry in decline, a sunset industry, which may actually not be sustainable in the future. And this would actually undermine the objective of the bill, of seeking to make the board self-sustainable and to defray their costs. A more prudent approach would be to exclude totalizators from the bill at this stage. The department could always consider charging fees at a later stage if there are changes in the industry and they are able to absorb the costs at that stage. And it's important to bear in mind we are looking at long-term sustainability, not short-term benefits. And long-term sustainability is not achieved by charging fees to an industry which has been shown to be in decline and which cannot afford the costs of hosting horse racing events unless they receive funding from government, and which may actually close if they are put under more financial strain. So there is actually a link between what government is trying to achieve and excluding the totalizator at this stage. With regard to bookmakers, in summary, the department has explained the following in respect of them. Bookmakers, the nature of the industry is different to the other three industries in that they are not required to have a physical address. Many bookmakers can operate online, and they can therefore be located wherever they choose to be. So if a province makes the environment too costly or too onerous for bookmakers, there is a real risk that they could leave the province and move to another province that is more favorable. And you'll see in my opinion that the board has also given an example of the flight risk associated with bookmakers. There was a case where a bookmaker relocated from the Western Cape to another province because the board would not permit the holding of a virtual dog race, while the other province permitted it. And it's also easier to enter into the bookmaker industry and to leave it compared to other industries. Bookmakers have lower costs. For example, building costs or equipment costs, they don't necessarily have such costs because many are based online. And that's why provinces impose similar tax rates, which vary between 6 and 6.5%. But unfortunately, there is not a standard approach across the country insofar as the charging of fees to bookmakers is concerned. So what that creates is, if a province makes it too financially onerous for these bookmakers to trade, there is a very real risk that they could just move to another province. And if the bookmakers were to leave, the board would be without the fees that they currently receive, and the province would be without any tax revenue that it currently receives. And I understand from the department that there are also developments in the area of online gambling, and hence national policy would have to be developed in that regard. And given the mobility of bookmakers, I also understand from the department that there are possible considerations of a national tax, to be charged nationally and then disbursed to provinces. Again, we must bear in mind that the aim is to make the board self-sufficient and to defray its costs long-term. It would not be sensible, once again, to link the self-sufficiency and the costs of the board to an industry where operators are a high flight risk. Given how the industry is set up, there is actually a real risk of relocation, and the board's example shows this. If bookmakers were to leave, it will place the board under financial pressure, which would then undermine the objective of the bill. So again, what Treasury is trying to achieve is to facilitate the self-sufficiency of the board. And in order to further this objective, they've decided not to include bookmakers at this stage. Again, it's not about short-term benefits, but long-term challenges, long-term defraying of costs and making the board self-sufficient. With regards to casinos and LPMs, just to understand the industry, there are essentially four players. There are the casinos, the LPMs, the bookmakers, and the totalizators. I understand from the department that bingo has not been rolled out at this stage, so we only have those four main players. If there are good reasons, and we submit there are, that two of them cannot be included at the stage with regards to the paying of operator fees, then logically, there are only two left to cover this burden. And the department has taken the position that the industry should pay for its regulation, and there's a need to also insulate the totalizator and bookmaker industries, because the totalizators could potentially close down. They are under financial pressure, and also the department does not want bookmakers to leave. So yeah, essentially we are left with two options. It's either the remaining industry players within the gambling model, the remaining two industry members paying, or the taxpayer paying. And the department has said that their position is that the industry should pay, and government funds should actually be redirected to important priorities such as health and education, for example. And this is not dissimilar to the approach that with regards to regulating the industry that is in the case of the United Kingdom and Australia, where industry generally pays for their regulation. And I know that the department has presented on this aspect as well. And it's not dissimilar to how the liquor industry also deals with this matter. Essentially, they have, if you look at the green paper relating to the alcohol harms reduction, they have indicated that government is overburdened and they need to recover more financial contributions from the industry in order to deal with the harms that alcohol causes. So there is a general trend in government thinking that industry should pay for the regulation. And in this case, the only two operators who are currently able to do so are the casinos and the LPMs. And it must also be borne in mind that most gambling activity takes place in casinos and LPMs. There are bigger players in the industry, and thus they cause more harm. And given the nature and complexities of this industry, the board actually spends most of its resources on regulating them. This involves more skilled staff, more staff generally, and also more man hours. Thus, it makes sense that the bulk of the board's costs should actually come from the casino and LPM industries. And again, they are the only remaining players that could potentially pay such fees. So in conclusion, the bill provides for casinos and LPMs to pay operator fees. It does not require totalizators and bookmakers to pay such fees. Thus, it differentiates between categories of operators. This is not inherently unconstitutional. And again, we are not looking at fairness, unreasonableness, or even appropriateness. We are simply looking at, is there a link between what government is trying to achieve and the means, i.e. the differentiation that they have used? So the objective of the bill is essentially to ensure that the board is financially self-sufficient and that its costs are defrayed going forward. The industry must indeed pay for the regulation, but this does not mean that all players must pay the same types of fees, or they must pay the same amounts. Who pays what, if anything, and when are matters of policy. And totalizators and bookmakers do pay certain regulatory charges. They will just not be required to pay operator fees at this stage. It is possible that the department could change their mind, but it depends on whether there are changes in the industries themselves. And so it's not just a question of timing. It really relates to challenges with the industries, with the totalizators and the bookmakers. So the department wants to ensure that totalizators are still in operation, and they don't want bookmakers to leave the province. And then the board can then continue to rely on the existing contributions they receive from these industries. And it will ensure that the model for the gambling industry is not distorted. Charging these industries would actually undermine what the department is trying to achieve, meaning the financial self-sufficiency of the board and defraying its costs. And again, the only parties who could pay for the funding of the board are the casinos and LPMs, alternatively the taxpayer. But the department has said that they want that funding to go to important priorities such as education, transport, health, etc. Charging operator fees to casinos and LPMs are capable of achieving the objective in the present circumstances, whereas charging totalizators and bookmakers are actually capable of undermining the objective. In the circumstances, there is a rational link between the differentiation and the objective sought to be achieved. In the circumstances I've asked to is basically charging casinos and LPMs is capable of achieving the objective. Whereas if you charge the totalizator and bookmakers at this stage, bearing in mind and knowing that the totalizator is under severe financial pressure and knowing that the bookmakers could exit, you could actually undermine the objective of the bill, which is to sustain the board long term. And this is why one can actually link this differentiation to what the government is actually trying to achieve. Thank you, Chair.
Thank you, Ms. Miller, for talking us through your opinion. Members, before I take your hands, I would just like to remind you to not take the verbal talking through the legal opinions as the official legal opinions. Please consider the written formats of both Advocate Maasdorp and Ms. Miller as the official versions. This was just so that they could talk us through it and so that members have an understanding of what they mean in their legal opinions. And I'm going to now allow for questions to the various persons who drafted. I will take the first three hands. Okay, members, I don't see anything. Does no one have questions? Okay, if there are no questions, members, how do you wish to move forward? We have now before us two legal opinions. Oh, sorry, I see Honorable Nkondlo's hand and then I see Honorable Mitchell's hand.
Thank you, Chairperson. I thought you were saying you are requesting hands from the drafters of the documents. That's why I think I didn't raise a hand earlier on. Pardon me. I had questions, I think, to both our learned colleagues that have just presented, so that it helps us to clarify the issues at hand. And I wanted to just pose to Advocate Mastod, I think, about the issues that he was raising. Because I wanted indeed a clear sort of explanation, including context, through which I think the issue of irrational of the differentiation, because that's how I understood what you were saying, is that the differentiation is irrational. And I then want to just check further, what that means. And I'm raising it when I'm listening to Ms. Muller regarding, the differentiation which she explains in the context of this particular industry, and the reasons why such would take place. And therefore, my question is such unreasonable? Because I wouldn't want, and he would explain to me if I'm misunderstanding him, whether by implication what he is arguing is that in any industry, and even in terms of law, there's a situation where everybody is treated and is assumed, to actually be on the same page. And as I was listening to him, already what came to mind is actually tax law, because what I understand, and I might be wrong, and maybe I can explain it from a legal point of view, is that I already see in tax law the application of differentiation, because not everybody is taxed the same. And I think such is allowed based on the economic context and the fact that we live in a system where there is varied income deciles, which therefore leads to the tax law applying in accordance, to what people earn. So is that once again, if we were to argue, from where he is raising, irrationality, would we then, if we use that same logic, say the tax law, and pardon me if I'm being simplistic, and I think he can try and explain this to me, because I was trying indeed to understand what he was arguing. Would we then say the tax law, is actually irrational in that particular context? And again, to him, does once again, in context of the law, not take into account, the contextual issues? And I think some of those contextual issues are what Ms. Muller is bringing to the fore, I think, in her explanation at this point, about, the nuances and the dynamics of the industry itself, if you consider what would be the implications, of that, the varied effects or impacts into, the different players in the industry. So I'm saying, and I'm trying to follow the logic, of the arguments of Advocate Mastod, of rationality. Would that, in legal terms, not be something that is taken into cognizance, that is the context and the dynamics, of the industry? And I'm raising this in terms of the different industries, whether you go to agriculture or any other, the different stakeholders, in that particular value chain will always not have, the same effects. When changes take place, they don't affect, the different players whether in terms of the size of those players, whether in terms of the different sophistication or levels they are in, in terms of the value chain itself. That is what, in that particular context would then apply. So that is why I'm asking once again that would the law, in terms of the principle of rationality, not take into cognizance the impact, which would be varied, in people in a particular industry. So I just wanted to understand those issues in terms of what Advocate Mastort is raising. I'm just going to stop there, Chair, and then maybe I might come back. I just wanted to go back also to my notes because the presentation of Ms. Muller, just the explanation actually, because she assisted, because some of the things when they are written, indeed, sometimes you struggle to understand. So it was good to just hear what is their thinking. I might come back maybe with one question to her. Let me end there for now. Thank you.
No problem. Thank you, Honorable Nkondlo. Honorable Mitchell, you put your hand down. Do you not have a question anymore?
No, Chair, I wanted to propose a way forward, but I'm not, in the interest of having this debate and having Honorable Nkondlo's comments and questions answered, I'm not going to make a proposal until we've exhausted going forward. Thank you, Chair.
Okay, no problem. Honorable van der Westhuizen.
Thank you, Chair. I would also prefer first to get the responses, and then I was also thinking of how to go forward, because I do admit that I don't feel myself equipped to be able to, say what is valid and what is at this point in time not valid. So perhaps if we could just first attend to Honourable Nkondlo's input, and then we will again think of how we should proceed.
No problem. Thank you so much. From my side, I think Honorable Nkondlo covered my questions as well. Advocate Mastort, I'm going to start with you with answering Honorable Nkondlo's questions. And then Ms. Miller, if there's anything that you would like to add from your side, because I think most of the questions was to Advocate Mastort, but if there's anything that you feel that you need to respond to, please then do so as well. Advocate Mastort.
Thank you, Chair. Chair, the issue of rationality, and I will just take a quote from one of the Constitutional Court cases, which I also quote in my opinion, which says that the requirement of rationality is not directed at testing whether legislation is fair or reasonable or appropriate, nor is it aimed at deciding whether there are other or better means that could be used. And this is the crucial point, Chair. The requirement of rationality, the use of it is restricted to whether the measure the lawgiver has chosen is properly related to the public good it seeks to realize. If we as Parliament accept this bill and pass this bill, then it means we as lawmakers accept that it is good law. It is coherent law. The law has integrity. If we as Parliament say to the industry out there, listen, industry, we are very mindful of all of you are in this industry. But at this stage, we are going to make a law that only affects some of you. And only some of you will carry the vast burden of financial obligations to run this industry. Simplistically put. Legally put, there should be a measure, the measure used to obtain an objective should be for the public good. The chosen measure should be for the public good. I am saying that, in fact, let me underscore this point by referring to the next question which Member Conlo raised, and I think it's a good illustration. Member Conlo talked about the taxpayers and the differentiation there. That is an easy example because the taxpayer block is differentiated per definition because of varied and varying income brackets, etc. That's an easy example. My colleague in paragraph 14 of her opinion, and I just want to read the actual words. If the chair will just give me half a minute. In paragraph 14 says, examples of mere differentiation include distinctions between lawyers or doctors, different types of prisoners, or income classification for the purposes of taxation or social welfare grants. Let me take those examples. And obviously, there are laws which apply to lawyers, laws which apply to doctors, and laws applying to different to prisoners. But even that reference is missing the point. If there's a law that seeks to deal with matters pertaining to lawyers, but that law says, listen, we are aware of you group of lawyers, but we at this stage will only make a law that pertains to lawyers that live in the southern suburbs. That categorization, that differentiation, I am saying, is an arbitrary one, is capricious, and does not properly and appropriately serve the stated objective. One cannot be countenanced to pass a law that seeks to deal with a category of persons, but within that category there's differentiation which has no rational basis. There may be policy reasons, but this law stands on its own 2 feet. It is merely predicated by policy, but the law itself stands on it, must pass constitutional scrutiny. On its own feet, this law should not differentiate arbitrarily. I accept, as Member Kodlem also mentioned, that there should be differentiation with taxpayers, but that is the nature of the context. In an industry where there are players, like the gaming and racing industry, it cannot be countenanced to have a law that arbitrarily seeks to differentiate between some who carry the burden and others who do not equally carry the burden. Let me just read one final paragraph, Chair. And this is what the National Gambling Board said. It says, and this encapsulates the essence and the underlying values that we seek to achieve, that all persons be treated equally before the law, without discrimination. And everyone is entitled to be guaranteed that those in equal circumstances are dealt with equally in law and in practice. How do we explain this to the casino and LPM operators? That this law just arbitrarily will treat them differently / unequally relative to totalizators or other bookmakers. There's an inequality in the differentiation as well. Let me leave it there for now, Chair.
Thank you. And to Ms. Miller, if there's anything that you would like to respond to or answer that Honourable Nkondlo has raised.
Chair, just regarding the issue that Advocate Marsfield raised now about the comments from the National Gambling Board, where they were concerned that the operator fee will be, the cost thereof will be paid, will basically be, how do they phrase it, will be passed on to the site operators. Provincial Treasury has explained previously that this is not the case. The charges will merely be paid by the route operators, and there's no carrying over of the costs to the site operators as well. So that issue has actually been addressed. And just generally, the reason why I'm saying there's no arbitrary differentiation is because if you look at the industry, you have 4 players. You have casinos, you have LPMs, you have the bookmakers and the totalizators. Provincial Treasury has explained that there are reasons, very good reasons, why they actually can't charge the totalizator and the bookmakers. It's not merely a case of timing, it's actually issues that go to the heart of the industries. So the totalizators, they are in a difficult financial position at this stage. And also they are an industry in decline. So it's not sensible to link the sustainability of the board to such an industry. And also the bookmakers, within the context of their environment. Again, it has been shown that they are a high flight risk. The board has given an example of this. So again, it's not sensible to link the board's sustainability to an industry like that. Because what must the board do if they leave? And then the board's fees cannot actually be covered. They cannot then be sustainable going forward. So logically, by process of elimination, you only have 2 operators left. You have the casinos and you have the LPMs. And also, you will see in my opinion, I discussed this, most of the gambling activity actually takes place there. So they cause the most harm to society, and hence the board actually needs to spend most of their time in regulating them. It's not that the totalizators and bookmakers will not be paying any fees at all. It's just that they will not be charged operator fees because, again, due to the nature of the industries, the department cannot charge them at this stage. So there is actually a link between what government is trying to achieve, which is making the board financially self-sufficient, defraying their costs, and differentiating between the types of operators. Because if you only charge casinos and LPMs, you can achieve your objective. But if you start including the totalizators and the bookmakers, you run the very real risk that you cannot achieve that objective. So you will actually undermine what you're trying to achieve. And that is why I'm saying that it is actually rational. And as the Honourable Member has pointed out, in tax law, there are some persons who pay more tax, some pay less, some are actually exempted from paying tax or filing tax returns. And some businesses, based on their profit thresholds, are exempted from paying tax. But I suppose the Provincial Treasury would be best placed to speak to that issue as opposed to me. But again, it's a case of mere differentiation, and all we have to show is that there's a rational basis for it. And like I've said earlier, I did not say, in my opinion, that the legislation is fair, reasonable, or even appropriate. That is not the concern here. The concern is actually, is there a link between what we as government are trying to achieve and this differentiation? And the department has explained this. Therefore, there is in fact a rational link, and the differentiation is not arbitrary. Thank you, Chair.
Thank you, Ms. Miller. I see that Mr. Phillips's hand is up, so I'm going to quickly take Mr. Phillips before I go back to Honourable Nkondlo.
Thanks, Chairperson. Maybe just not on the legal opinion, but each province actually has its own gambling legislation. And unfortunately, actually, that gambling legislation actually actually also differentiate across even the same players in that in other provinces. So in other words, in this country, actually, we have a monopoly around the casinos as well as the LPMs. And these operators actually operate in different provinces, actually, and they are subject to different taxation as well as laws, gambling laws in all of these provinces, basically. So there is a sense of differentiation across the provinces, actually. And I think our colleague actually from Legal Services actually raised the issue around differentiation with regard to individuals as well as companies, actually, based on also on income, and those actually that have been exempted with regard to that. So I think also what we also actually put on, actually, these things have almost a contextual background as well, in terms of the board was to a large extent self-sustainable. And that board actually was self-sustainable based on the exclusivity fees, and it was self-sustainable casino exclusivity fees, as well as they were self-sustainable with regard to the LPM operator fees. Now, I've actually, when in the response to the committee, I've actually highlighted actually when these fees came to an end between 2010 and 2016 on the exclusivity. It was actually met with extensive litigation, actually, up to this point in time, actually, that those are fees that have been lost. Likewise, actually, with the LPM operator fees, which have been reintroduced with the 19th Amendment, actually seeks to address actually the issue around the regulation and self-sustainability of the board. So there's a context in terms of where the board finds itself. There's even a context in terms of the same players, basically, in both the LPM as well as the casino space, basically, that actually is at the heart of the current dilemma in terms of making the board self-sustainable. From a economic and fiscal perspective, Chairperson, all provincial departments or governments actually and national governments has been severely cut with regard to its revenue or income. The point is actually that all of them will have to make hard choice. And how do you make a hard choice between an industry that is able to regulate itself and the operation of an ECD or a health facility, wherever it may be, where vulnerable people also live, that has been exempted from the taxation system, basically, on a differentiated basis, basically. So for me, actually, that's probably at the heart of what is trying to be achieved. Actually, it's an industry that regulates itself, and that actually, based on effort even between the industry, the biggest effort actually in terms of regulating the industry lies with the casino and the LPMs, noting actually that this is actually a high risk actually for other social ills actually that's associated with an outcome actually of an industry that's unable to regulate itself, whether it's based on the industry player is not able to pay, or whether government is able to fund the regulation of the industry. So in a nutshell, that's where we are, Chairperson.
Thank you, Mr. Phillips. Honourable Nkondlo, you indicated previously that you had more than one question. Do you have any other questions there now?
Thank you, Chair. Not necessarily a question, because I would have wanted, I think, Advocate Musdorp, to argue, this issue of arbitrary, because I think that is what he is raising, is that arbitrary, which I may assume in terms of my pedestrian English, is that, I mean, there is nothing significant reasons. And I think reasons which are contextual reasons are being placed, because I think he makes a rider, to us as the legislature in his response, which I think for me, what becomes important is assisting us to understand, because this is why at this point I'm not hearing when he argues that there are arbitrary reasons that are being placed by this particular bill, whilst there is ample explanation that is being provided. I also wanted to check with Ms. Mola, if I think on one hand, I think it's just been clarified now, by Mr. Phillips,
the situation of the different legislations in the other provinces, because I think also for me that would have been important to consider, in terms of case law, or to consider in terms of practice what has been there, in the public space in terms of regulatory practice, of this particular industry, where we can also once again draw, this particular indication, of this particular legislation imposing somewhat, an arbitrary, way in dealing with the different stakeholders of that particular industry. So I think Mr. Phillips raises one, but I also wanted to check that and maybe the Department of Economic Development would have also assisted just to give us an indication, of the regulatory environment in the different economic sectors, whether there is one in terms of the argument of good law, because this is one concept I think Advocate Masdor speaks about, good law. If indeed, good law, if what I'm understanding from him, argues, being purist, where you apply something across board. I think my little understanding, my little experience, to where I am now, and I'm always open to be educated, is that given, the kind of economic and political environment, I've not seen, maybe in another economic system, but in the current one, I've not seen where you've got any law that actually, present itself outside of the differentiated, because that's unfortunately how the current economic system present, whether it's industry, whether it's citizens, in a differentiated manner. If you look from a class point of view, where others, by virtue of them working, or others by virtue of them owning means of production. So I'm really, because I'm wanting to heed the caution that Advocate Masdorp is providing us. So that is why I'm saying, in any way, maybe the Department of Economic Development may also have given some examples in the different economic sectors or industries where, you do have, such a situation where this varied context, will then, in terms of regulation, present such a differentiated application. It may not necessarily be fees, but I'm just saying, I think the principle we're driving here is exactly the example that I was making, where, the different stakeholders are defined, as I think Advocate Masdorp has explained, in tax law, in terms of income brackets, those are defined. What is different in the context of the different players in the gambling industry, which is the bookmakers and their standing in the chain, of that particular sector. This is where I think I'm not sure if indeed we are moving from the same premise in terms of this particular argument, both from Advocate Masdorp and both from the department's legal opinion. It seems, I think this is a point where I think there is a divergence, because there's an explanation of a definition, of these bookmakers, which I hear Advocate Masdorp not necessarily taking into account, unless I'm missing him. And I don't want to belabor the points, Chair. Perhaps if indeed, in terms of the committee, you can allow the responses, if there are any, maybe the committee might have a better appreciation. But I'm really struggling to find, because I'm just seeing, a difference that I cannot sort of appreciate where exactly is the point of argument. Thanks.
Thank you, Honourable Nkondlo. Advocate Masdorp and Ms. Miller, I'm not sure if there's anything new you would like to respond to, but if there is, then you're welcome to do so now, because I would also like to ask the members of the committee how they would like to move forward. It is quite a difficult situation, obviously, at the moment, because I would never want to undermine anyone's opinion, especially if it's an official legal opinion. And since we've received two different opinions, it's also obviously quite difficult on the committee. And as chair, I need to also protect the committee as a whole, as a collective, in order for us to make sure that we have done everything to ensure that we have made the right decision. Advocate Master, was there anything specifically you would like to respond to?
Maybe, Chair, just the following. I truly appreciate the input by Member Nkondlo. When I said that the exclusion, or rather the differentiation between the fee payers and those excluded is arbitrary, what I argue is that the decision by Treasury to just exclude them, I said in my opinion in the written one that it seems that the exclusion is not one founded in principle, or is not a fundamental one, but is an expedient one, in the sense that, as Treasury has considered in their responses in the matrix, that at this stage they do not consider the inclusion or the payment of X fees by those other players. I'm saying for that reason, it is a chance exclusion. It is one that is not driven by necessity, but by expediency, not driven by principle, but again by expediency. And I actually say, and I want to read this. What I said earlier in my written opinion, I said that Treasury is laboring under a self-imposed imperative, that they have created this context that they seek to use as predication for this bill. And I accept what Mr. Phillips is saying. In fact, it is correct what he is saying, that those who comprise the majority, or rather the bigger player in the industry, like casinos and LPM operators, they should pay more. I accept that. The remedy, what would really disengage any objection to this bill, is to say to the others who've been excluded to pay a negligible amount because of their relative negligible contribution. In other words, a proportionate amount relative to the size of their stake in the industry. That will save the skin of this bill. But to merely, to perchance exclude them, I say is arbitrary. And that is slap bang within the definition of arbitrary. A chance decision, one not based on principle. Like I said, this is a self-imposed imperative. The remedy for this bill is to include everyone and proportion the obligation for payment. Then there can't be argued that the exclusion is irrational or outside of the law. Thank you, Chair.
Thank you, Mr. Masterwort. Mr. Phillips, I did see your hand, but I'm going to allow opportunity for Ms. Miller and the Department of the Premier first, because they were the drafters of their opinion, before I take your hand. Ms. Miller, is there anything you would like to add?
Chair, there's not much that I would like to add further because it is traversed extensively in my written opinion. But just this issue that I'm not sure is coming through, but operators do not have to be treated equally. All you have to show is that there's a link between what you're trying to achieve and the way in which you have treated the different operators, the differentiation. So the department have explained it's not on a whim, it's not just because of timing, it's not for short-term expediency. There are real challenges with the two industries. And because of that, that is when the timing comes in. Because of the challenges, the department actually can't charge them at this stage. But if in the future the industries change, there might be a recovery from the totalizators, or there might be better regulation regarding online gambling, and it is possible, and this issue of flight risk is not an issue anymore. Then, yeah, then the department could potentially consider at that stage whether or not it is able to charge those operators fees at that stage. But right now, because of the nature of the industries, it is not possible. And those are good reasons for excluding totalizators and bookmakers. And just with regards to the issue that Member Nkondlo raised about trying to understand differentiation in different contexts, perhaps it would be prudent for the department to maybe speak to that issue. I know Mr. Phillips has given some background, but perhaps the department could elaborate on that a bit more, because they would be in a better position to actually explain how this works across the provinces. But other than that, I do not have any further input apart from what I've said now. Thank you, Chair.
Thank you. Mr. Phillips, I saw your hand earlier, but then you put it down. Do you still have something to add?
Yeah, yes, Chairperson. I think actually Astrid actually covered most of it, but I think the big issue is actually currently, I mean, if you want to actually look at the arbitrariness actually of the consideration at this point in time, it is actually that at this point in time, actually, that horse racing is really struggling. And then obviously any taxation, currently actually with horse racing, actually government actually provides them a subsidy or a rebate. And therefore it's an industry actually that if by any chance any further challenges actually will actually make that industry close down the totalizators. Then on the bookmakers, I mean, bookmakers basically do not have, like the others, a physical address basically. So therefore, basically, most of them actually do their business in a virtual environment or an online environment. There is currently under consideration actually online gambling legislation being considered by the national government, actually together with provinces, actually that will address actually the issue around online gambling and how that is actually managed basically as a country really. But where we're sitting basically is that a bookmaker actually, whether it's a one-man concern, because many of them actually are one-man concerns basically, they can actually locate and operate from an IP address in any other province actually, and not be actually subject to any operator fee basically. So I think the point actually, there is currently national legislation underway actually to look at online gambling and legitimizing that. I think based on, and I think actually we've actually highlighted actually to the committee as well, that each province actually operates in its own gambling legislation. So you have a Gauteng gambling legislation, Western Cape gambling legislation actually, and they differ based on actually how the industry and how the acts have been conceived within the various provinces. It also differs basically in terms of the size of the industries. Basically, it also differs basically on what type of LPMs basically are located, or at least the type A, B, or C, whatever, which means actually that in our province actually we rolled out LPMs type A, which actually limits actually 5 LPMs per outlet. However, in other models actually there might even be some facilities actually with 10 to 20 LPMs actually within the same location. So it's different how it's been configured across the provinces. So drawing up actually a provincial comparison, that's one issue. There's also an issue actually, look, we've tried to do both an aggregated 6-stream tax system, but however, or tax bands. However, there might be other provinces, given the relative size of the various casinos basically in the province, actually that determines basically the tax bands and also what accrues on a taxable. So drawing up a simplistic comparison across provinces actually also be defeating the aims, because look, for example, in our case actually one of the biggest there's a vast cliff between the GGR of a Grand West as opposed to all of the other 5 regions basically where there are casinos. So just drawing up a comparison across the provinces, which you also have a challenge. For example, in Gauteng, there might be 3 or 4 big casinos that actually have GGR relative closer to each other, as opposed to the big difference actually we are seeing. And then obviously in our case, actually it was a decision actually to roll out 3,000 LPM machines, and we have 2 operators actually that are actually doing these machines actually across, but they're also linked to either one of the 2 casinos actually in the province. So it's actually basically all the LPMs and all the casinos actually are monopolized in this province actually to 2 operators. In actual fact, it's actually almost the case in South Africa as being the case. So I think it was a number of considerations, and in our response to the committee, we've highlighted the thinking process actually that underpin us actually going this route, highlighting basically the challenge that we have with casinos and LPMs actually, and also the fact actually of how we've actually gone through the decision around actually waiting for the national legislation that will bring a fairer dispensation moving forward with regard to that. I think the point of differentiation has been well articulated by our legal team. And the approach actually that we are taking moving forward is that there will be national legislation actually that also looks at it for the country across the 9 provinces and also impacting on online gambling. Thanks, Chairperson.
Thank you, Mr. Phillips. Colleagues, I do believe that we have exhausted this topic. However, before I ask that I take the views of members of how we should be moving forward on this matter, I would like to request whether we could please take a 5-minute comfort break and then come back at 10:35, if that's okay with everyone. Members, are you okay with us taking a 5-minute comfort break?
In order with me, Chair.
Okay, thank you so much. So 10:36, we will then resume with the way forward on this particular matter. So please do stay online. Thank you. Check if everyone is back and if we may proceed. Members, are you still online with us?
Okay, back. I'm back.
Yes.
I'm back.
Thank you, Member Mitchell, Member Nkondlo, Member van der Westhuizen. Are you back yet? And I see Honorable Makamba Bocha joined us. Member Makamba Bocha, are you in the meeting?
Yes, Chairperson. I've been in the meeting. I think I was late by like 50 minutes or so. But
Okay. Okay. Member van der Westhuizen, are you still with us? Are you back from our break yet? Okay, let's maybe just give it one more minute and then we'll start. Okay, Ms. Adams or Ms. Kluter, I saw on the participant list that Member van der Westhuizen's name disappeared. So perhaps he's having some connectivity problems. If someone could just check in with him so long while we then continue with the meeting. Members, we are now going to deliberate on the way forward as we have received 2 legal opinions with differentiating views. And I will now take hands from members on how they feel the committee should be moving forward on this matter. Honorable Mitchell.
Thank you, Chair. Chair, let me state on record as a proviso that I am mindful and I value the legal opinions received from both legal practitioners. And I am in no way disputing the validity, correctness, or the actual substance and facts as provided to the committee. But Chair, as we heard, there is throughout the deliberations there are still questions that the legal practitioners amongst them are not, if I can use the word, agreeing on, and that's absolutely fine. I mean, a legal opinion is a legal opinion, and for that reasons we have a court system where such things are very often tabled and debated and brought forward. But in the interest of and my concern today is how do we as a committee take this matter forward, and I would like to propose that we perhaps get another legal opinion that we write to the speaker to request permission to obtain a third legal opinion, and then from a different legal practitioner or another legal practitioner rather, and then we can then take it as a committee, take it from there. Thank you, Chair.
Thank you, Member Mitchell. Are there any other views on the way forward? I'm going to take members first. If none, I actually would like to then expand on the proposal from Member Mitchell, that when we then, if we agree that we should be writing to the speaker then and request the third legal opinion, and this I agree with actually is because as a committee, we need to satisfy ourselves that that we are making the correct decision based on law. And since the law or the way the law should be implemented or interpreted is in dispute, one does not want to say one or another is incorrect in their legal opinion. So I do think that we need someone who's impartial on this matter. So perhaps if we then write to the Speaker's office, we then ask for an external provider, possibly for the Speaker's office to assist us with such, for them to then consider the same question of constitutionality, but also for them to possibly advise us on, if it is not constitutional, that they provide us with possible remedies that we could apply going forward. I see the hand of Advocate Maastorp. You may go ahead.
Thank you, Chair. Two things, and maybe the less important one first. Chair just mentioned now that there may be a preference to obtain an independent legal opinion. I would want to believe, with respect to you, Chair, that the use of the word independent is an imprudent one, in the sense that I would like to believe that all opinions, in fact those emanating from me, are independent and only motivated by what the law dictates and what the facts conjure. However, it may be that there's a need for an external legal opinion, and I'm sure in as much as you use the word independent, you actually meant an external opinion. That's the less important observation. The one that is somewhat more alarming to me, and here I step into the shoes as legal advisor of provincial parliament and not necessarily the author of an opinion, is that, and Member Mitchell mentioned it, an opinion is an opinion ad infinitum, an opinion is an opinion. I am not sure, in as much as it may be the right or the instance of the committee to source a further opinion, I am not sure whether a subsequent or new or external opinion will change things, because the majority of opinions is exactly that, just that. It's a majority of opinions. That's one. Two, at some point, this committee will have to commit to a decision either way. This committee is the entity that recommends to the House that a particular law or a particular bill should be passed. This committee will commit either way to a decision. If we find an opinion, an external one, that supports one particular opinion, will that swaying opinion be sufficient to support this committee in a particular decision? Because either way, there will be an entity that draws at the shorter end, which will have consequences. So in as much we want to extract an opinion from external practitioners, at what point do we stop? What if another member in the committee suggests, after another opinion, for another opinion? At what point do we stop and defer the commitment to take a decision? Thank you, Chair.
Thank you. On the first part that was related to my use of the word independent, you are correct. I did mean external and not independent. I do not wish to imply that anyone's opinion is not independent, so please excuse me for that particular wording. What I meant is an opinion that is not from the Western Cape Provincial Parliament, an opinion that is not from one of our governmental departments, which then would be an external opinion. But before I move forward on this matter, I'm going to first take Honourable Mitchell and then Honourable Makamba Bocha's hands.
Thank you, Chair. Chair, I don't know if you want to allow the other members to make an input first, or if I should just respond to the comments made.
Member Mitchell, your hand was up first, so please go ahead, and then I will take the other hands in the order that I've received them.
All right, thank you. Chair, I want to, just for the record, state that the reason why I'm making the proposal for an external legal opinion is because when we eventually make a decision on the way forward, that we have exhausted all possible legal avenues to in good conscience say that the process and all legal opinion or all matters were taken into account. I want to again state that at no point am I disputing or questioning the legal opinions provided. And as a person, I personally resonate with a particular view, but that doesn't mean that that's necessarily would be the view of the entire committee. And in order to make sure that we are doing this absolutely correct legally, that's the intention of that proposal. Thank you, Chair.
No problem. Thank you, Honourable Mitchell. Honourable Makamba Bocha.
Thank you, Chairperson, and my apologies for being late in the meeting. I've missed out in almost everything that was being discussed, but I managed to grasp what the meeting was all about. I just want to express my gross dissatisfaction in the manner in which this committee operates, when a majority of members in this committee do as they please when it suits them, and they are only doing things when they are not satisfied with whatever legal advice they are getting within the parameters of legislature. For an example, I just want to make an example of an incident where we were doing recruitment for the gambling board, where there was an incident of the matter of the tax-related matters, where one of the members or one of the interviewees was not in line with the processes in terms of compliance with the tax compliance. Then the meeting decided that they would seek advice from within the legislature, of which Mr. Mastop was actually the one who was giving advice. And that was the only advice that was taken from him, even though some of the members were not satisfied with the manner in which the matter was dealt with. There was no third-party legal advice that was being mentioned in this committee. So I don't understand why are we now having an opportunity to seek an external legal advice when there is a legal advisor within the legislature who will then give us a directive in terms of what transpired in the meeting. So I'm really very dissatisfied in the manner in which we operate in this committee, because when the majority of people feel the other way, then we must seek alternative legal advice, and we don't consider what we have within the legislature. Thank you.
I will respond to some of the committee matters afterwards, after I take all the hands. Honourable Nkondlo.
Thank you, Chairperson. I think what we should be considering at this point, Chair, is that we're sitting with two, in my view, sort of conflicting legal opinions. And I take heed from Advocate Mastorp that if the third one or the fourth one or the fifth one comes up, does it mean, we will continue, I think by implication in what he's saying, not take an opinion, and defer the decision, because when all is said and done, as members, we've got a responsibility based on these advices, and insights, to come to a decision. And such a decision is a decision that we need to consider, the issues that are brought to the fore. So why I would even consider what has been proposed of a third legal opinion from where I'm sitting is the fact that here we are sitting, and I'm speaking from myself as a member in this committee, with both arguments that have been placed here, that are placing valid reasons, in terms of the for and against, but where I think for me there is a challenge is actually depicting this constitutionality, which is a very important issue, I think, from where we are as a committee, to ensure that whatever decision that we're making is based on and passes constitutionality. So, Chair, I think two issues I would have also, not two issues actually, one issue I would have added is actually to consider what would have been, the grave, if any, or material impact or effect if I think what has been proposed as a recourse or as a correction or recommendation by Advocate Master in terms of the fees, I think, to the bookmakers, which are in accordance, I think, to the consideration. I just forget the term that he used in terms of that fee structure. What would be, the serious implication, in trying to align such in the discussion. And that is why I'm saying, if for any reason can also that particular principle be applied, to the third opinion, to understand whether such would be of significant impact or not, I think it's something that must be included in such a terms of reference to consider that particular recommendation. But I honestly do not think that there's anything wrong, if indeed as a committee, we believe at this point, given the advices that we've received, we are not at a position to make such a decision, and we call for an additional assistance in actually understanding what we are sitting with and we are confronted with to decide, so that also we are not blamed at making an arbitrary decision, notwithstanding respecting the opinions, because these opinions, as we have debated them now in this meeting, are actually helping us to further have a better insight into the issue at hand. So I'm saying, Chair, in a nutshell, I am in support of going and getting that particular opinion from the speaker, which is an external opinion at this point, that will then in itself also consider, the arguments that have been placed based from the industry, I think, as where the matter originates from, and the two legal opinions, that we have received in an advent to try and get ourselves into a decision on this bill. Thank you, Chair.
Is it only on my side?
Yes, we can hear you. I think the chair must have lost connectivity. Chair, are you back?
Yes, I am back. Thank you. Are you able to all see or hear me and/or?
Yes, we can, Chair.
Okay, I lost connectivity right after Honourable Nkondlo. I was about to take Honourable van der Westhuizen's hand, I think.
Yes, thank you, Chair. Chair, thank you very much. I want to support Honourable Nkondlo, who seems to support the notion that we do ask for somebody to drill a little bit deeper in terms of the constitutionality issues that were raised. Can I just ask that, when such an opinion is sought, it is also sought on a number of other aspects of the act, which is again addressed in this bill, where I fail to see the rationality of it, such as, for example, the fiscal cliffs caused by severe cutoffs, such as infrastructure development of 150 million rand, where there's no timeline linked to that. For me, as somebody who was confronted with the legislation only a few months ago for the first time, it just doesn't make sense that a person with a development of 149 million must be treated differently, that a person with one less machine should pay so much less than somebody with one machine more, and so on. So please, I would really appreciate it if we could have those issues and those questions that we have in this regard being addressed by somebody who would now have the benefit of the two conflicting opinions, and who would then therefore be able to perhaps extract from those differences, what would be constitutional and what would be able to help us to overcome any questions. It's for me, I think we should be prudent. I wouldn't like any piece of legislation passed by this body to be successfully challenged afterwards. And therefore, I would like us, even if some people might feel it's now belt and braces, I would like us to, rather than take that cautious route, than to cause legal uncertainty and legal challenges, etc. Thank you.
Thank you, members. Okay, I'm gonna just respond to some questions that were posed to myself, and also add to also some of the input that have been received from members. The first part is, even if we get a third legal opinion, it does not necessarily mean that the committee will agree with a third legal opinion, and that's obviously based on the information or reasons that will be put in the opinion. And I'm going to be very honest, there is a particular opinion of the two opinions that we've received today that I'm leaning more towards, and it's because I also consider the environment that we are in, the sizes of industry players, and so forth and so forth. However, I myself do not want to dispute one opinion or another, and I do feel that we should probably get an external opinion in order for us to see what reasons such third person would put forward as to why or why not the differentiation would or would not be constitutional. And the reason for this is not to say that we would agree with that third opinion, or we're going to disagree with one, or we're going to agree with the other. But the reason for that is because I feel that when it comes to constitutionality, I'm not talking about agreeing whether something should be law or not be law, or whether something is factually correct or factually incorrect. And I think we must also then distinguish between where we disagree on fact in some other situations, and where we disagree on constitutionality and where we disagree on law, because those are different things as well. And in terms of the fact that there are disagreements on the constitutionality of the differentiation, that we do need to be more prudent than usual. In terms of that, I do support Honourable Mitchell's call for requesting then the third, but that we write to the Speaker and request such. We don't know, the Speaker's office might come back to us and indicate to us that based on the legal opinions we've received, that they do not necessarily feel that they should request a service provider for us. However, such request does need to go through the Speaker's office, because in the end, if for any reason the bill ends up in court, it is the Speaker of the Provincial Parliament that represents the Provincial Parliament in such matters. And as such, the Speaker's office needs to be satisfied that we have also exhausted all internal resources in this particular matter. The reason why I also suggest that we also ask the third party or the external provider, whichever correct legal terminology one would like to use, regarding possible remedies, is that if we are going to get an opinion on the constitutionality, if the opinion comes back and says that they also believe it is not constitutional, then as a committee, we at least need to know what are our options going forward. Is it possible to remedy the clauses or the objective? For example, one might say maybe the objective need to be written differently. Who knows? I do not know. So we need to then know what our remedies are, possible remedies are going forward. Honorable Mkondlo then went further and asked whether we could ask the Speaker's office what the impact would be of including the totalizers and bookmakers in the operating fees in this particular bill. Am I correct by summarizing it that way, Honorable Mkondlo?
Yes, Chair.
Okay. And then Honorable van der Westhuizen went further and asked whether the whole bill could be considered by the third party or service provider, the constitutionality of the bill. While I do not think that the issue of the development fee structure compared to the gross revenue structure is a question at this stage, I do not mind it being included in the question, although I'm not sure whether it would be prudent for the simple reason that because we didn't exhaust the internal resources on that particular question, I'm not sure if we're allowed to then ask the external provider, but perhaps Advocate Master and our procedural officer can advise us on this particular point. And again, yes, once we get a third opinion, it doesn't necessarily, like, where does one stop? I do think, however, that as chairperson, my job is not to protect myself. My job as chair is to protect the committee as a collective. And I've heard from the committee members that we have now received these two legal opinions that are differing. And that some of us, we do lean towards one opinion rather than another. So the committee needs to direct me or mandate me then as chair in order for us to request this from the Speaker's office. But I'm going to first allow for legal and for procedure to advise us if there's maybe something that we've gotten wrong, or if there's a particular process that we need to undertake, or if there are certain things that we're not allowed to ask for, things that we are allowed to ask for before I put it back to the members. I'm going to start with legal. Advocate Maastorp, if there's anything you would like to advise us on.
Chair, maybe not offhand, except to say that it will be very crucial to, and in this way, I am referring with respect to my colleague Muller as well. It will be very crucial to get the brief to an external legal practitioner right, so that the salient points which we were seized with are sufficiently canvassed for the benefit of the committee. But also, now that we've had further input, in particular from Member van der Westhuizen, that the brief in respect of, it seems, what he says, the general constitutionality of the bill. That is a big ask, and that is a very wide, if you like, subscription to give to a legal practitioner out there. I'm not sure if he's committed to that question, but if that is the case, then the brief in respect of the external legal practitioner will have to be very crucial, how it is articulated and the particular wording used, so that we benefit from the response, because it is very likely that if the brief is even in a nuanced way different, that we may get a response that is not sufficiently helpful for what we seek to canvass as lawmakers. Thank you, Chair.
Thank you, Advocate Marstorp. Ms. Miller, is there anything you would like to advise us on the possible procedure forward?
There's nothing further from my side, Chair. I'm happy with the proposed approach.
Okay, Ms. Adams, is there anything from a procedural point of view that you would like to advise us on, if any?
Thank you, Chair. I think from a procedural view, there's not much I'm going to add except to say that we asked the external opinion. Procedurally, there's no rule about that guides us, but as long as we stick within the legal realm of what we ask them, then it should be fine.
Okay. Members, can I then ask the following? Can I ask that you then mandate me for the following? That I will write to the Speaker to then ask whether we could source an external service provider on this particular question. But before that the brief gets submitted to the external provider, that I meet with the Office of the Speaker. And that meeting needs to then be the legal unit of the Western Cape Provincial Parliament, the procedural unit of the Western Cape Provincial Parliament, a representative of the Provincial Treasury, and the legal unit of the Office of the Premier, because the Office of the Premier's legal unit deals with the legal matters of all the various departments. And that we sit together, all of us, and that we need to agree on the brief that goes to the service provider, but that these questions need to, at the minimum, include the current question before us, the constitutionality of excluding the totalizers and bookmakers from this particular operator fees in this particular bill, that such include the possible remedies going forward, and that we include the impact of including the totalizers and bookmakers regarding the operator fees in this bill. Now, those might not necessarily be the exact wording, but the reason I asked that we should possibly have this meeting is so that then the legal eagles can advise us on how the brief should be written. And I'm not 100% sure whether the inclusion of the general constitutionality of the bill should be included, because that is very broad, and that is not a question that internally we brought before us. But regarding the general constitutionality of the bill, could I then in that meeting ask the Speaker's office to advise us, and that I then, regarding the general constitutionality, bring that answer back before such is then submitted? Would that be in order, members? I will take hands from members now. Honourable van der Westhuizen.
Yes, thank you, Chair. Well, whether constitutional or not, the question for me in the first instance is whether it is rational to have those financial cliffs in the legislation. And perhaps we could first get an opinion then on that. How were those cliffs determined, and how, I almost want to say, on earth can this be seen as rational cut-off points? And if there's somebody else that would like to advise us in that regard beforehand, I would be most happy to hear those opinions.
Okay, Honourable Nkondlo.
No, thanks, Chair. I would want to sort of come closer to what I think Advocate Marstorp has raised, because I think at this point we're sitting with two opinions from the department and himself as the parliamentary legal unit, you know, and based on that, we have decided to seek further advice. So for me, I think if we are able to stick to that so that we may be able to be clarified on that matter without, conflating it with other issues, unless we were to have either 2 points so that we separate. I think the point that member van der Westhuizen, is introducing now, for such an opinion. But I believe, because we do not want to conflate, and then when such an opinion comes, it is said we have reintroduced, so we can't, therefore, if we have to make any reference, we can make reference on the 2 previous opinions that have triggered the request of that external one. So I'm just saying, in terms of that process and context, for me, it is important that we stick to, using the basis of the argument that we're sitting at hand with, unless we can then, and we are allowed to sort of request an extra as another separate issue, so that there is no confusion on the matter that is at hand. Thank you, Chair.
Okay. Can I then ask that I then ask the office of the speaker that I meet with himself, and the respective representatives that I've now indicated, to advise us on how to write such a brief, that we request, obviously, assistance with procuring an external provider on this particular brief, but then that I then ask for advice in that meeting separately regarding how to go forward on asking advice on the issue of whether it is the current fee structure proposed in the bill is rational. Because the internal legal opinions we received was on a particular matter from the Western Cape Provincial Parliament, as well as from the Department of the Premier. So if we ask for an external provider for an opinion, we are actually then increasing the scope of the questions we are asking without having internally exhausted our resources on those particular questions. And I'm just concerned that we will have nothing to compare such with, as it would be a completely different question. Advocate Master, you have your hand up.
Chair, I'm just addressing the committee as legal advisor to Provincial Parliament, just in relation to the issue of the reference by Member van der Westhuizen regarding the scale and the cut-off point and what he calls financial cliffs. With respect, that is not so much a legal issue. That is very much in the realm of policy. A department or any unit can decide whatever cliff, whatever demarcation, whatever cutoff they want. That is a policy decision. And with that in mind, I would really suggest that it would not be at least even cost effective to seek legal opinion on something that pertains to policy. That's the first observation. The second is, and having been exposed to this myself in the past, it is, and some of the Afrikaans words come to me, dis 'n onbegonne taak to request an opinion on the constitutionality in general of a bill. Because one, as a practitioner and as a deep diver, will then of necessity have to unpack every provision and test it for constitutionality. That is insurmountable. In fact, it's an untenable brief to ask. Rather, to have a brief that is so sufficiently specific that it is helpful to consider and to internalize the advice that is forthcoming. So I would suggest for Member van der Westhuizen, with respect to you, to reconsider that request for an opinion on the issue of what he calls financial cliffs. And I would also suggest a review of a brief that would want a opinion on constitutionality in general of the bill. Rather fine-tune it a bit more for assistance to the practitioner, him or herself. Thank you, Chair.
Thank you, Advocate Marstorp. Members, are you happy with Advocate Marstorp's suggestions? I'll go through the members list. I'll start with Honourable Mitchell.
Thank you, Chair. Yes, I agree with Honourable Marstorp, but just for procedure, before the bill got to us, it went through legal mustering as a bill, right?
Yes, yes, there was a legal proofreading that they did.
Okay, just needed to get.
Okay.
Thank you.
Honourable van der Westhuizen, is it on this topic that your hand is up? Either way, Honourable van der Westhuizen, what is your view regarding the suggestion from Advocate Marstorp?
Yes, thank you, Chair. I raised my concerns now because I wouldn't like us to extend or to delay the whole process. And what I'm hearing from Advocate Marstorp is that he is saying that those cutoffs are rational and that it will pass, therefore, that test of rationality. I fail to see it, but I would accept his opinion on this. Thank you very much.
Thank you, Honourable van der Westhuizen. Honourable Nkondlo, your view on Advocate Marstorp's suggestions?
I'm okay with them, Chair.
Okay, Honourable Makamba Bocha.
Chair,
no comment. Okay. Let me just write that down. Okay. I'm also comfortable with Advocate Marstorp's suggestion. And with that, unless there are any specific objections, I now take it that I'm mandated to go forward with this proposal. I will now allow for any objections, if any. If none, then the committee has mandated me accordingly, and I will thus then bring feedback after such a meeting. Members, I would thus like to request that for now that we take the possible informal and formal consideration of the bill off the program for now, and that we wait until we receive feedback before we schedule a date for such deliberation. Members, would this be in order with you? This would simply just be so that we don't put ourselves into a box for a particular date.
Supported, Chair.
Supported. Other members, you also happy with that? Yes, no, maybe. Okay, I will take it as no objections. Mr. Phillips, I see your hand is up.
Chairperson, thanks. I know actually that we wouldn't want to be put into a box, but I think the reason why this bill is actually with the committee is exactly around the sustainability of the board and also the functioning of the board regulating actually the industry. And I think actually, look, in this case, actually, where we're sitting with actually is that we're sitting with a board actually that can collapse because of not having adequate funding. There might be certain ramification on the broader public actually and also the scandal around either corruption or everything that actually can arise actually if we do not have a functioning board. Chairperson, just maybe on that, just the timing around this.
Thank you, Mr. Phillips. Well, I appreciate your input. I do think that as a committee, we always try to reach consensus on decisions within this committee. And I would like to, as far as possible, for members to reach consensus on matters regarding the bill. And only where absolutely necessary do we really go to a vote on matters such as this. And I would like us, and while you represent the department, and while others represent their respective institutions, the committee has elected me, and I need to also look after the interests of this committee, because if we take wrong decisions, it will reflect upon the provincial parliament, and then I'm going to have the speaker in my email inbox. So that is why we need to be prudent with matters such as this, especially when it impacts on finances. Members, with that, we have now concluded this matter. We will obviously postpone the further deliberations on this particular bill until we have feedback, and I will convey such feedback accordingly. Members, we can now move on to committee business, and I will this now allow the officials to leave us, as our committee business have mostly to do with our upcoming oversights. But I would like to thank the legal advisors, the officials, procedural officers, and all those who were able to assist us today. I know it could not have been easy, and it's not always a fun environment when one disagrees with one's colleagues, but the world is such that sometimes we will not be disagreeing on a particular topic. And with that, I excuse you from the committee.
Thanks, Chairperson. Thank you.
Thank you so much. Okay. Members, I will thus now continue with our general committee business. Firstly, I would like to remind members of the visit to the Eskom Ankerlig power station, as well as the Atlantis SEZ on the 15th of October. A few things. Members, if you are traveling with the Provincial Parliament Transport, you must please meet at the Dorp Street entrance, and that on that day we'll be leaving at 7 o'clock. Further, members, please bring proof of identity because it is important for Eskom especially to be able to identify us, because it is a national key point. And thus, because it is a national key point of security reasons, they must ensure that our full names and IDs are according to what has been submitted to them. Further, members, we will have to fill out a screening questionnaire that must be submitted to the security at Eskom before we enter the Ankerlig premises. And our procedural officer is going to print our questionnaires and bring it along, but our procedural officer will also forward the electronic copy for members that will be using their own transport. And we please ask that you fill it in and print it out and bring it with if you are coming with your own transport. Further, Eskom has stated that all visitors will obviously undergo the COVID-19 screening protocols on entry to the Ankerlig power station, and that face masks be worn at all times. Further, members, we please request that you wear closed, flat shoes, and that no photography will be allowed at Eskom unless permitted by the plant manager. This is a general safe example. You want to take a photo of something that someone can sabotage. So that's for that particular reason, because it's a national key point. However, if we wish to take photos, because sometimes on oversights we take a photo to show that we were at a place, on the walkabout, as chair, I will then ask the Eskom officials, for example, if it's allowed to take those type of photos. And I am confident that if it's a general a photo of such sort, that they would allow that. But we also need to be cognizant of potential breaches due to photos. Further, in terms of the GRI walkabout, so what we did was with the Atlantis SEZ, we asked the department and Atlantis which companies have contracts with the SEZ, and if we could engage with those companies that have interests and contracts specifically there at the SEZ. And one of the companies that have contracts is the GRI, which is the biggest investor in that area. However, unfortunately, GRR have asked that instead of us doing a walkabout on that particular day, that we please do it on a different day because they're unable to accommodate us on that day. And then, so the question that I just then put to members is that at the Atlantis SEZ part, that we have all the respective briefings, but then that we then schedule a separate walkabout day where we go and engage with the businesses who then obviously have the contracts with the SEZ, so that we can hear and see how that is occurring there. And then further, another thing I need to note with the committee is that Ankerlig currently does not allow catering to be brought onto the premises and does not have a canteen to allow for guests to eat comfortably. And therefore, we will have to, as a committee, drive to a restaurant. And that we have scheduled additional time for this because the restaurants are quite a drive from the plant. And that's another question that I would like to find out if everyone is okay with. And then finally, just a reminder that while we do allow public to come to our oversights, that if anyone that is not on the members list or officials list of the committee, please remember to email your full name and ID to the procedural officer, Ms. Adams, because she will need to check whether there's enough space in each venue. So for example, because of the new level 1 restrictions, you could have up to more than 50. It's not like previously, you can have up to, I think, 250 people in a venue. However, every venue can only take up to 50% of its capacity. So for example, if a boardroom can only take 10 people, then 50% is obviously 5. So even if the regulations allow for more than 5 in general, the venue is 50%. So that is why it is crucial for us to also know what the full names and ID numbers are, because if we do go onto private premises or if we go into national security key points, then for security reasons, those particular stakeholders need that information as well. And the RCP is so that the procedural officer can ensure that as a committee that we do not break the laws. Members, okay, I see Honourable van der Westhuizen's hand. Honourable van der Westhuizen.
Thank you, Chair. This is a personal note. I've been requested to attend a meeting at 8 o'clock that morning, which I first declined, and arrangements have subsequently been made for me to attend it virtually. I expect that meeting to not last longer than an hour. Do we have a program of, if you leave at 7 o'clock from Cape Town, what time would you like to expect members that would be traveling by private transport to the venue to enter? And would it be able for me to only enter or to just have a safe spot in my car where I can attend this virtual meeting until 9 o'clock on the day? Because I would very much like to, as you would be able to deduct, I've actually prioritized the Ankerlig meeting above the other one, but it seems to me that my presence is required at the other meeting.
Okay, Ms. Adams, I just want to find out if we leave at 7 o'clock, what time would we end up at Ankerlig on the day?
Thank you, Chair. So I've double checked with our logistical unit. We should be okay to get there, I think, by 8 o'clock or just after 8. But I have scheduled another half an hour so that we can make it through security. So the meetings are really just supposed to start at 8:30. So we do have an hour and a half.
Okay, so Honourable van der Westhuizen, I will ask Ms. Adams just to alert Eskom that you'll be coming in your private vehicle, because then perhaps if you are then there before us, you can then stay on the premises in your vehicle and perhaps have your virtual meeting and join us when that has been completed. However, we will then be starting at 8:30 with our Eskom meetings on the day. For example, at the Eskom venue, because the Eskom venue is also so small, I've asked that only the officials that present at the time of the presentation be in the actual room. Otherwise, we'll be breaking the law in terms of regulations. And that Eskom tries to put the extra people in extra offices, and then virtually they are then in our meeting while we are there. and that then if there are anybody that wasn't physically in that same room, then we can, I'll then allow them to then have first bite of the cherry of the questions when we do our walkabout, for example, so that we try to accommodate the fact that not every entity and not every stakeholder has really big rooms. Member van der Westhuizen, would that be able to assist with your request?
Yes, thank you, Chair. I trust that we would be allowed to keep our telephones on, and I would then communicate with the procedural officer on the day.
No problem. Other members, do you have any other questions? Okay, if none, then colleagues, thank you so much for today. I know it's been a long morning, but I always appreciate the robust discussion, and thank you so much for showing how passionate we are about ensuring that good law gets passed by the Western Cape Provincial Parliament. And I'm confident that our committee is that we are really doing whatever we can to ensure that we are prudent and doing whatever we can to ensure that we are working in the best interests of the public. And with that, the meeting's adjourned. Thank you so much. Goodbye.